Good evening, everyone. It's Chris Fleury, Counsel for Canadian Women's Sex-Based Rights, or CAWSBAR. It's April 17th, 2025. By now, many of you, I'm sure, have heard the news that COSBAR has brought a lawsuit against the federal government. And I just wanted to take some time to explain some of the history here and explain what the claim is and what the claim is not. So, by way of an overview, the claim alleges that the transfer and placement of biological males who identify as women is causing a vast array of harms to female inmates. The lawsuit alleges that these harms and risk of harm constitute breaches of sections 7, 12, and 15 of the Charter, of the female inmates' rights under section 7, 12, and 15 of the Charter. Section 7 is the right to life, liberty, security of person. Section 12 is the right not to be subjected to cruel and unusual punishment. Section 15 is the right to equal protection and benefit of the law without discrimination based on sex or other protected characteristics. The claim also pleads the related provisions of the Canadian Bill of Rights. So I believe it's helpful to go through a little bit of the history of the placement and transfer of trans inmates by Correctional Services Canada. So prior to the year 2017, transfers or penitentiary placements were based solely on an inmate's genitalia. What that means is that a trans-identifying male inmate could only be transferred to a women's prison if that person completed what was then termed sex reassignment surgery. There's some case law on this, which is also helpful to understand. So in 2001, a federal inmate named Cynthia Kavanagh sought transfer into a women's prison. At the time, this person had not completed any surgery and still had intact male genitalia, although this person still, they identified as a woman. The request for a transfer was denied, and it ultimately resulted in a human rights complaint to the Canadian Human Rights Tribunal alleging discrimination. So at that time, the Government of Canada not only opposed the transfer, but defended the human rights claim by bringing its own expert evidence. This is a case called Kavanagh and Canada AG 2001, Canley 8496. So in that case, Canada's experts, who were two psychiatrists and a psychologist, they opposed the placement of pre-operative trans persons into a female prison. All three experts thought that there was a risk that the trans inmates would prey on female prisoners. And I encourage everyone who's interested to go and read this case. It is a lengthy case. There's a couple of other issues in that case, and all of the issues are complicated. I'm not going to summarize them all here, other than to say that the Human Rights Tribunal agreed with the Government of Canada's position at that time. And I should also point out that Cynthia Kavanagh did eventually undergo the surgery and was eventually placed in a women's prison after undergoing the surgery. So what changed is the question that allowed pre-operative trans-identified male inmates into a female institution. So in the year 2017, Canada passed a law called Bill C-16. That law, among other things, amended Canadian human rights legislation to prevent discrimination on the basis of gender identity and expression. Around the same time, the Corrections and Conditional Release Act was also amended, and that added the phrase gender identity and expression. Respect for gender identity and expression was added to its guiding principles. An interim policy was put into place by Correctional Services Canada, and at that time, that interim policy allowed for the first time in Canadian history the placement of pre-operative male inmates into a female institution. That interim policy was ultimately replaced by a directive called Commissioner's Directive 100, and that sets out the process and procedure for placing and transferring trans inmates. And it is that directive, Commissioner's Directive 100, that COSBAR is taking issue with in the claim. So why do I bring up this history, which admittedly I've gone through in very broad strokes? I say this to emphasize how uncontroversial COSBAR's claim actually is, and that in many ways it aligns with the position of the Government of Canada prior to the year 2017, the position that it took in legal cases like the case of Kavanaugh. And COSBAR is really seeking or is asserting claims that are in many ways in line with positions that the Government of Canada took not so many years ago. I also, as I mentioned, wanted to say some words about what this claim is not before I go into any aspects of the claim. The claim is not a claim that all trans people are dangerous. It does not concern all trans people. The claim is fundamentally a claim about the rights of women in the context of incarceration. So I'm going to read directly from the claim for a moment, which I think will be helpful. A sentence, this is at paragraph 17, a sentence of 2 years or longer is required for a person to qualify for a federal prison sentence in Canada. Serious criminal activity and or a lengthy criminal record is required in order to qualify for such a sentence. For this reason, trans-identifying male inmates housed in federal institutions are not reflective of the general population of trans persons in Canada. It's very important to emphasize that this claim, it does not assert that trans people are inherently dangerous or predatory or anything like that. The inmates within federal correctional institutions are not reflective of the entire Canadian population, or in this case, the trans population. So, flipping to the first few paragraphs of the lawsuit, who is bringing the lawsuit is COSBAR, as I mentioned, the Canadian Women's Sex-Based Rights. They're, for those who may not know, a federal nonprofit. They advocate for the sex-based rights of women and girls. In particular, they advocate for the sex-based rights and protections in the context of prisons, like in this case, but also washrooms, changing rooms, and sporting competitions, and other venues that have traditionally been reserved for women. COSBAR is not, as you might imagine, is not asserting that it has suffered harm in this case. I believe with one exception, the members of COSBAR have not been inmates in federal custody, so they are bringing this claim on behalf, or they seek to bring this claim on behalf of all female inmates in Canada in federal institutions. They're seeking what's called public interest standing to do this. And the reason that they're seeking public interest standing is they claim that it is difficult or impossible for an individual female inmate to bring such a lawsuit. So, moving past that, I want to go to what is really a foundational aspect of the claim, and this is at paragraph 9 and the paragraphs following. Men and women are different, and that is a fundamental assertion in this claim. And those differences, they differ biologically as well as psychologically, and most importantly, for the purposes of the claim, those differences between men and women manifest themselves in the context of incarceration and criminal justice. So, reading from paragraph 10 of the claim, the next paragraph, it gives a number of examples of the way that these differences manifest themselves. Female inmates are substantially less likely than male inmates to have been convicted of a serious violent crime. Female inmates are less likely than male inmates to be repeat violent offenders. Female inmates are substantially less likely to have been convicted of a sexual offense. And female inmates are, on average, shorter, smaller, and physically weaker than male inmates. The claim goes on to assert that the trans-identified male inmates retain the characteristics of their biological sex and not their chosen gender. Also want to highlight another important aspect of this claim that many of the listeners may not be aware of. What happens in federal institutions is certainly outside the day-to-day reality of most Canadians, but what is, I'll just say what is pleaded in the lawsuit is that female inmates are a vulnerable group, that they are much more likely than the general population to have been the victims of physical, sexual, and psychological abuse. And this abuse is often at the hands of men. And it is in that context that the claim alleges a lengthy description of harms that female inmates have suffered, including physical and sexual assault, sexual harassment, physical and psychological harms, and impacts on programming, rehabilitative programming. The claim goes on to plead, as I mentioned, Section 7, 12, and 15 of the Charter and the corresponding provisions of the Canadian Bill of Rights. One final aspect to this claim that I want to highlight is the final pages of the claim include an appendix, and the appendix has a list of definitions that are used in the claim. Some of these, the reason that we had to define some of these terms is that we anticipate that they're going to be controversial. So most importantly, male and female are defined in relation to reproductive biology. A woman is defined as an adult female, and likewise a man is defined as an adult male. And I contrast this with Correctional Services Canada's definition of sex that's contained within Commissioner's Directive 100. It does reference in part biological realities, but then it goes on to say, and I'll just read it directly, for the purpose of this Commissioner's Directive, the sex of an offender is determined solely by their current genitalia. And what that means is that a male inmate, upon completing surgery, could, or I should say would and will, be defined as a female inmate after that. So I'll leave it at that in terms of the claim. We're at very early stages. The claim was filed this morning. It could take years and years before we get to any trial or conclusion of the case. There are certainly a lot of steps between now and then, but as soon as there is a more pertinent update, I will come back and hopefully give you another video.